fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Welcome to the show. I am your host, Daniel. Had to think for a minute. Sometimes we get those brain farts. I want to say this before I go on. I'm not worried about this channel ever being monetized. One, it's too small. Two, it's not a big thing to me. I just come on here and I do my thing every day, and I'm off. Some people like it, some people might not like it. I want to say this too. What happened in the past should be left in the past. And somebody once told me that you should let bygones be bygones. Fighting on YouTube is not necessary. Fighting amongst creators is not why I signed on to YouTube. I think that if we are creators and we should act accordingly, but we also should help each other if we have questions or problems with stuff. No fighting, no personal attacks and stuff like that. I don't think it's necessary. I find it highly irritating sometimes. But that's not what we're here for. And if this channel ever did reach 500 subscribers, I'm not going to monetize. It's not worth the effort. So YouTube can turn around and say, oh, we're going to demonetize you because you're not authentic. You don't see my face. I'm a real person, okay? I'm a real person. You see me right here. I'm a real person. Hi. I'm a real person. Yes, I hide behind an avatar because sometimes things happen. The only time that I'll actually be in, you will see my face is if I'm doing something like a video, if I'm making some kind of video content, you will see my face. Most of the time, I hide behind an avatar, but I am a real person. As you can see, I'm a real person. And I started in 2000. I created a YouTube channel in 2015. By the beginning of 2016, I was monetized. When they changed the rules of being monetized, that you had to have 1,000 subscribers. You had to have 2,000 or three. You had to have 3,000 subscribers, 1,000 subscribers to monetize, and they took my monetization away. I just don't think it's worth it. It's not worth having to work hard every day to do this to be demonetized. It's like I said before, all the people in the past, we should leave what happened in the past, and we should move forward. Everybody is welcome on this channel. Everybody is welcome on this channel. It doesn't matter who you are, you're welcome on this channel. The people that were banned from the channel at the beginning of the creation of this new channel, they're not banned anymore. They're not banned anymore. I don't believe in banning people from the channel. The only thing that I ask is you behave yourself and act like adults on here, and that's it. Have respect for me, have respect for the other people in the chat, and that's it. Everybody's welcome here. I found my niche, whatever you want to call it, doing these things with the courts. And I'm happy doing it. Talking about the two fleas is very stressful. It's a lot of work. Especially if I have to sit there through listen to a 2-hour live stream or more live stream and taking notes and then have to come back and talk about it. It's just a lot of work and it's a lot of stress. Here, I'm not stressed out by doing this. By all means, I am not stressed out by doing this. We have wonderful mods on this channel. And I appreciate everybody that comes to this channel. It's like I said, everybody is welcome here. You know, I don't believe in banning people. I don't attack other people. I do my thing and I'm off. So when we hit the 2-hour mark or whatever, we hit the 2-hour mark, or after the 2-hour mark, I'm done for the day. And while if Megan is doing a live stream or Tug is doing a live stream, I'll be setting up the next live stream for tomorrow. Oh, if you guys want to see the shit, if you guys want me to bring back the scanner live feed, please let me know in the comments. If you want me to bring back the scanner live feed, I was just doing it to see if it was how that would play out, and it was working out okay. So it's no problem with me bringing that back. It's not a problem with me bringing that back. But being monetized, I'm going to tell you the honest truth. YouTube doesn't pay all that much money when you're monetized. Unless you have really good content and you're making really good money off that content. Me fixing computers and doing stuff like that, fixing electronics back in the day, and that's what the basic channel was. Was doing that stuff. Working on people's TV sets, getting them set up. That's the kind of content that I put on my channel. I did a video on an RCA remote. They got thousands of views. I did a video on a Vivitar, an old cheap $2 Vivitar. That thing got over 4,000 or 5,000 views. I'm not into this for the money. I'm just doing this because I want to feel useful. I don't want to sit around here and don't do anything. That's not me. If I can come on here and show judges and what's going on in the court systems and make people understand this is real. This is, there are consequences to committing crimes. And if you watch any of the content on this channel, you will see that, especially with Judge Fletcher, who is my favorite judge. I hate to say this, but to make this sad announcement that Judge Middleton is retiring at the end of this year, and Judge Boyd, she didn't win the re-election, so she's out at the end of the year. And there was a big controversy about Judge Boyd putting her court on the YouTubes. And speaking of YouTubes, please, by all means, please share these streams out on the interwebs. Let people know that this channel is here and what we are talking about on this channel. So today is Judge Alyssa Perez. So let's get started with our judge today. I didn't mean to be talking, something that came up maybe a couple of days ago. I was searching for something on YouTube, and it was starting a bulletin board service in modern times and dialing in the bulletin boards and all that other stuff. And it brought back memories because I ran a bulletin board service from 1995 to 2001. By the end of the 90s, beginning of 2000s, the internet had taken over and killed all the dial-up bulletin boards. And it's a sad thing. I had quite a few games on that system. I had Legend of the Red Dragon, Baron Realms Elite, Solar Realms Elite, Trade Wars 2002. What other games did I have on that? Usurper. Freshwater fishing simulation, which I played a lot in local mode. Just keeping with Judge, it brought back good memories of the past. I might have had some bad experiences with YouTube, but I let that go, and I kept moving forward. But let's get started with Judge Perez. Nobody wants to hear me yakking my mouth. So I'm going to share the screen. Make that bigger. I am going to be here, but I have to watch for ads. Because ads with music in it, if I don't catch it, YouTube will actually copyright strike my channel for it. So I am going to be here. I am going to be watching. If you have any questions, please leave it in the chat. I will try to answer your questions as much as I can. So let's get started with Judge Perez.
Resuming the civil docket for the 210th District Court for January 28, 2026. Again, all matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Nunez, would you call our next case, please?
Yes, ma'am. On page 5, Judge, calling cause number 2025 DCV 3807, Jesus Arturo Nevares versus Encino Metals LLC et al. Announcements, please.
Good morning, Your Honor. Jacob Ray on behalf of the plaintiff, Jesus Nevares.
Joseph Gagnon for both defendants.
And we are here. We had this scheduled a few weeks back. I can't remember if it was 2 or 3, but I think we had a somewhat new response from plaintiffs, and so I allowed move it to an additional time to review and file. And I do see we have an additional filing in this case on the motion to stay proceedings and compel arbitration. Sir, you may proceed on that.
Thank you, Your Honor, and I appreciate you providing the additional time for the briefing and the briefing schedule. So I think that allows the parties to go forward this morning. I represent both defendants. This is a case arising out of the employment of Mr. Navarez as a driver with Encino Metals. Encino is a client company of ESI, which is a PEO, per the terms of their client services agreement, which is an exhibit to, I believe, our reply. There's an arbitration agreement that Mr. Navarez signed that applies to any disputes arising out of his employment with the quote company. Company is defined in that agreement as ESI, the PEO, and its client companies. The argument, as I understand Mr. Navarez to be making, is not that Encino isn't a client company, but that he simply did not know this, that this was not made clear to him. There is no such requirement at law in Texas. There's no requirement that there be an identification by name of parties to or parties that are covered by an arbitration agreement. He signed the agreement. The plain language applies to ESI and its client companies. There's no requirement that an intended third-party beneficiary be named or known. We've cited cases to that effect. In re Citgo, which is a case from the Beaumont Court of Appeals, but it relies on the second restatement of contracts and a Supreme Court decision from Texas in 2002, Stein versus Stewart. In addition, there's a case from 2011, Supreme Court of Texas, in re Rubiola, where again, the parties that were not named by, specifically in the arbitration agreement were allowed and permitted to enforce the agreement. Cielo Property Group versus Mulcahy, again, as well, applies to G&A, which is a PEO, and its quote clients. The ruling in Cielo Property Group did not hinge on whether the parties stipulated as to who was or was not a client. The courts simply looked at the plain language of the agreement. The plain language here makes clear that Mr. Navarez is required to arbitrate claims with ESI and its client companies. There is no dispute, and there can really be no dispute that it is a client company. We've provided the CSA. It's the only reason, I mean, whether it's a plausible argument or not by Mr. Navarez that he didn't know that of this relationship between Encino and ESI ultimately is irrelevant. They are a client company. Client companies are included in the arbitration agreement. So I would again, I move the court to go ahead and grant the motion, compel the parties to arbitration.
And thank you, sir. I failed to note that there was a plaintiff sir reply that was also filed on the 23rd. Mr. Ray, you may respond.
Thank you, Your Honor. And, the big question here, I think, is whether any notice was provided to Mr. Navarez as to who he was being compelled to arbitrate against. So while the arbitration agreement with EESI does vaguely state companies involved, there is no mention of Encino at all in any of these documents, any of the onboarding documents that he signed. As you can see in the SIR reply, the portion that was filled out for employer use only was done the day after Mr. Navarez signed his onboarding package, which includes the arbitration agreement. There is, some confusing language, I would argue, for a layperson to even understand the nature of a PEO. There is no evidence presented by defendants whether this was explained to him prior to signing, whether Mr. Navarez had the opportunity to consult with counsel prior to signing the arbitration agreement. So with that being said, I don't want to dispute that Mr. Navarez is contractually bound to arbitrate with EESI. That's clear by the documents because EESI is specifically labeled as one of the parties there. However, with no mention of Encino, this is opening up the gate for any single one of these companies that are by proxy working with EESI to be bound by this arbitration agreement. Now, who is that to know whether it's the locations as to where Mr. Navarez is dropping off, loads of metals, whether that be some type of premises case against that company, whether it be his employer, we don't know. And there is no proof provided by defendants to show that Mr. Navarez was aware of the intricate yet distinguishable relationship between Encino Metals and EESI. This is a 2017 agreement. My client didn't start working with them until 2024. That agreement is specifically bound, the CSA agreement is bound between the two defendants themselves. There is nothing that shows that Mr. Nevares knew of the relationship between the two parties. Now, for example, I just filled out some 401k and some healthcare information here at the office. I sign my employee part, then that's given to the employer and they fill out the rest. That's the only way that Encino was actually mentioned, which wasn't done until my client already turned in his paperwork. And so to show that there was some meeting of the minds and my client understanding that he was going to be waiving his rights by compelling arbitration against Encino as well just isn't there. And if we look at the test for substantive unconscionability that was put out by the Supreme Court in the Henry Palm Harbor case that we put out, it's given the party's general commercial background and the commercial needs of the particular trade or case, the clause involved is so one-sided that it is unconscionable under the circumstances existing when the parties made the contract. And Mr. Nevares does not have any commercial background of the sort to understand the complexities of the relationships between a client company and a PEO, much less, what he was waiving at the time of the arbitration.
All right. Anything else on this?
Very briefly, Your Honor.
Yes, sir.
I appreciate counsel's comments and arguments. I do. I think that they seek to impose a requirement that doesn't exist at law. There is notice provided. The notice is sufficient. It applies and requires arbitration with ESI and its client companies. That is sufficient. That is sufficient at law. There's no requirement that an employee be required or permitted to confer with counsel before signing an arbitration agreement. The agreement does say, read this very carefully. It does provide that admonition before it provides the jury waiver, which in Prudential has made very clear. Parties can contractually waive that. It's not unconscionable whatsoever. But the notice is sufficient. And the employers provide arbitration agreements all the time. That doesn't provide a disparity. They are enforced routinely by our courts from one end of the state to the other.
Okay. All right. Anything else, Mr. Ray?
No, Your Honor, and I would agree that they are consistently upheld and there's actually a preference, to engage in arbitration once one is signed. But that's assuming that the parties do understand what they're getting themselves into, which I just don't believe is present here. And so courts are in the position to determine whether any type of unconscionability did take place. So I just ask the court to please review the dates in which everything was signed and the circumstances in which it was signed. Many of these employees, they can't start work, until they complete this paperwork. And if I'm looking for work, I need money, I need to put food on the table, sign this paper and you could get started, then I do just that. But to say that accurately reflects the understanding of the parties at the time the arbitration agreement was actually signed, I think falls short. That's all, Your Honor.
Great. Gentlemen, I think I'm good. I do want to review, obviously, everything that's been filed with the recent filings and the exhibits that are attached there too. So I'll have some a ruling for you very shortly. I know we're also set for a scheduling status conference, but we'll bypass that for now. I feel comfortable saying that we can have that scheduling status conference in 3 weeks. So we'll reset that one if we need it. Okay. So, all righty. Thank you very much.
Thank you, Your Honor. We excused.
Yes, have a good day.
Appreciate
You
it.
as well, Your Honor. Thank you.
What else do we have? Let me see. Oh, our bench trial. Let's see. Let me admit Miss Barbosa. Mr. Sims, I'm going to assume is on that case. Mr. Sims, Miss Barbosa. Good morning.
Good morning, Your Honor.
Hi.
Barbosa, you're
Good
back.
morning. Yes.
Let's see. Looks like we have a bench trial.
Yes, Your Honor. Plaintiffs at this time wish to non-suit this case, and we can send in an order to the court as well as the previous one.
Okay. Just let me get on the record really quick so we can just document it. 2024 DCV 4152 LVNV Funding LLC versus Erica Velasquez. May I have announcements, please?
Yes, Victoria Barboza for LVNV Funding.
And Trenton Sims for the defendant, Eric Velasquez.
And as we were discussing briefly off the record, we are set for bench trial. My understanding, Ms. Barbosa's plaintiffs are non-suiting this case.
Yes, Your Honor.
Thank you very much. Thank you all for appearing. I'll await the order granting non-suit, order non-suit forwarded to the court. We'll sign off on it. Thank you very much. If you don't have anything else, you all are excused.
Thank you. Have a great day.
Thank you, Your Honor. Y'all have a good day.
Bye-bye. There it is. Good afternoon. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for January 21st, 2026. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. I will call our afternoon case today is cause number 2022 DCB 3599 Myrna Yolanda Quiñones et al. Versus Greenwood Motor Lines et al. May I have announcements, please?
Good afternoon, Your Honor. Daniela Lebinalti and Jeff McElroy for the plaintiffs.
Good afternoon, Your Honor. Jaime Peña, Jeanette Garcia, and Bill Minucci on behalf of the defense. We're ready to proceed.
And we are set today, somewhat of a continuation of the hearing that we had. Golly, was it on the 12th? The 12th of
Yes.
January?
Yes, Your Honor. I believe all the experts testified, and I think the testimony of the experts concluded. I believe Mr. Peña asked for the court to hold off the ruling because they were arguing to the court that somehow their experts were lacking some of the medical records, even though they were sent to them at least in December. But
So
either way,
hold
I
on a
did
second.
argue.
So let me interrupt you real quick. So what I understood, Mr. Peña, you were going to do an audit of the medicals in light of all the testimony that we had on that day to verify that there was nothing outstanding. What is the result of your audit?
Your Honor, I'm going to just verbally give you a summary of the result, but then Ms. Jeanette Garcia actually conducted the audit and she can give you some more specifics.
Okay.
We took a look at the productions that took place in this case, and as the court pointed out at the Daubert hearings, quite frankly, which from our perspective, the evidence is not closed on, but the court pointed out that there's a disconnect going on here with regards to an MRI that supposedly took place within roughly 6 months. The experts that we proffered to the court, Dr. Santos and Dr. Nadal, were relying on MRI films that took place about a year after the accident. Ms. Labinati extensively cross-examined them based on MRI films that they did not have and hadn't seen. Well, it turns out, Your Honor, that the discovery had closed on November 5th. On November 10th, Ms. Labinati and the office produced a bunch of records that we'd never seen before. One of the records, or actually two of the records from June of 2021, indicated that Dr. Johnson had seen some MRIs from a Legent hospital. We had never even heard of Legent Hospital in this case in any of the records that we had seen. We didn't know that there were MRI records associated with Legent Hospital. And so it came as a complete surprise. It wasn't until December 10th that we received those records. And quite frankly, we were ambushed at that Daubert hearing.
Hold on a second. Hold on. So you're saying December 10th? I had heard on November 10th.
Oh, no, November 5th was the date that the discovery closed. December 10th was the date that those documents were produced. They did not include the MRI films, but there is a reference in two of the records to Legent Hospital in records that we'd never seen before, frankly. And by the way, which are not reflected, Legent Hospitals nowhere reflected in any of the initial disclosures or responses to any of the written discovery that we've provided.
Okay.
Let me know when you want me to respond, Your Honor.
Well, let me hear from Ms. Garcia. And so I want to kind of just have my own mental timetable here. The original special setting was the 5th of December. We had our motion for continuance hearing back in October. Golly. Okay. All right, Ms. Garcia, go ahead.
Is it okay, Judge, if I share my screen so I could present you the chronology we prepared for you?
Sure.
And can you see my screen, Judge?
Yes.
So what we did here, Judge, is we went through all the medical records that we received from plaintiffs plaintiff's counsel regarding these MRIs and specifically Dr. Johnson. I noted the dates that these medical records reflect, the date they were received, how we received them, and by who we received them. So initially, Judge, when this case started, we received medical records from Dr. Johnson. Here it notes September 14th, 2023. And I want to point out, Judge, that here in the chronology of the medical records that we received, it notes May 26th, 2021 is when plaintiff, our belief, initially sought treatment with Dr. Johnson. And then after that, she presented again with Dr. Johnson March 25th, 2022, continued treatment in 23, and then the last treatment date we have for this record is September 1st, 2023. Again, the medical bills that we received in September 14, 2023 reflect exactly the medical records we received. We move along through time. Now we're in August 2024. Plaintiff's counsel presents their plaintiff's second supplemental notice to intent to use billing records. In these records, she supplements with treatment dates from September 28, 2023, noted through April 3rd, 2024. We continue. Now we're in September 10th, 2024. Again, we receive additional medical records from 23 through 24. On September 10th, the medical bills reflect what has been previously produced. Additional treatment date for June 12th, 2024. Then, Your Honor, we ourselves prepared DWQs to Dr. Johnson's office. Same thing.
Hold on, Ms. Garcia, let me make sure I'm understanding. On that last number 4 and 5, there is a June 12th, 2024, right? Treatment
Oh,
date.
yes. And the medical bills reflect the same thing that, yeah, that they reflect the same thing that as treatment is ongoing and time passes, plaintiff is continuing to supplement discovery for that later treatment dates. And then we do our due diligence and we sent over DWQs as well to Dr. Johnson. Same as I put as same as number 3, the same medical records that we already received from plaintiff's counsel. We received from Dr. Johnson through DWQ. At that same time, which is we're in March 19, 2025, we also submit DWQs to Dr. Johnson requesting any radiology records. We receive that DWQ back and it notes none, no radiology CDs or films. Okay, we move on. Now we're in May 22, 2025. Medical bills, we receive more medical bills from DWQ. They reflect the exact same things we have already previously seen and plaintiff's counsel has already produced. We now go down to June 3rd, 2025. We receive medical records through email by plaintiff's counsel. Again, same records, it's just as an additional record for treatment plaintiff underwent February 27th, 2025. Medical bills on that same date reflect the records and the treatment. So she has additional treatment February 27th, 2025. The medical bills reflect that as well. Again, we receive our own records from Express Records. No additional medical bills, dates, same as what we've reviewed above. So, Judge, these that I just went through, number 1 through 11, these are the records that we've received through discovery, right? Through supplemental disclosures, DWQs, affidavits, and these are 1 through 11 are the records that ourselves we've reviewed, we've relied upon, our experts reviewed, our experts relied upon. Then, Judge, I want to point out to number 12, which this is the critical issue. On December 10th, 2025, we received something called Plaintiff's Exhibit 17. In these records, these medical records then contained medical records from treatment in 2021. So, and I'm just going to go back a little bit, Judge, on the top. As you see throughout this entire litigation, it was our understanding that plaintiff only sought treatment one time, May 26, 2021, with Dr. Johnson. It wasn't until last month, December 2025, that we received records in 2021 from Dr. Johnson, which was Plaintiff Exhibit 17. Those records are February 2nd, 2021, May 21st, 2021, and May 29th, 2021. What's critical about May 29, 2021 is that plaintiff underwent 3 x-rays that were not reflected on any of the other medical records because we did not have these records. What's even more critical, Judge, if we look here, June 9th, 2021, June 28th, 2021. In June, there's an MRI at Legion Hospital to the right shoulder. And then on June 28th, there's an MRI at Legion Hospital to the lumbar spine, L5, S1, L4, 5. These are the records, Judge, as you recall at our last hearing, that plaintiff's counsel cross-examined our expert with, noting you've never seen these records, you don't have these records. She extensively talked about these records. Well, these records were never disclosed, never produced until December 10th, 2025. And I'll continue, Judge. There's more records after these MRI records in 21. August 16th, 21, August 31st, August 13th, and then there was a February 1st, 2022 record. All these records were produced for the very first time where plaintiffs sought treatment in 2021 last month. And more critical, Judge, it's noted, as you see here in Dr. Johnson's report, MRI at Legent, he notes reviewed from portal, but there's no date. So when were these MRIs taken? When did you receive these records? We've never seen a report. We've never seen, till this day, we're still missing the report, the radiology films. We still don't have that. All we have is Dr. Johnson referring to these MRIs and these findings. We don't know if these findings were Dr. Johnson's findings, the radiologist at Legent, that's still unknown. And then same thing, the records, the medical bills that we received, Plaintiff Exhibit 18, reflect the above that we just went through. Additional treatment in May of 21, June of 21, that was never seen before. And Judge, if you would just allow me to just give you a quick example of how it looks, just so you could kind of see where I'm coming from. This is a business affidavit of records that we received for Dr. Johnson. This is what we're looking at to cross-reference with our medical treatment. So here it notes May 26, 2021, which we noted from the very beginning. Then it shows that the next treatment was until March 25th, 2022. So all those 2021 medical treatments that we just went through where she received those 2 MRIs at Legent, not noted in the bills. We go through the bills, 22, more treatment in 23. Plaintiff continued to seek treatment in 24, and then it stops right here. February 27, 2025. And then if we look at the bills that we received last month, which was December 2025, it's consistent, Judge, with what we've received. It shows May 26, 2021. Next treatment wasn't until March 25th, 2022. Everything consistent what we've received. It's not till you get to the very last page where you're like, wait a minute, there's now treatment in February of 21, May of 21, all these treatment dates on 21 that have never been disclosed, never been produced. They're produced on the very last page of these bills that we received last month. So even, Judge, by doing our due diligence, cross-referencing our bills and our records, we just received this with this added treatment in 21. So there was no way of us knowing that these MRIs existed, that plaintiff sought treatment. And as Mr. Peña noted, Legent Hospital, where plaintiff received these MRIs, are not listed in plaintiff's fact witness list, plaintiff's expert disclosures, plaintiff's exhibits. We have no records, Judge, whatsoever for Legent, but these are the records that plaintiff was relying on to cross-examine our experts. And I just wanted to lay this out, this chart for you, just so you could kind of see everything we did when we received it. So you could see when we received it, and if you had any questions at all, I welcome them in case, you know, you have any questions on this chart.
No, well, so what I am understanding is that at least a subset of some of this information produced on the 10th of December of 2025 were at least one of them, I know for sure, if I remember correctly, was the subject of kind of this questioning back and forth where I know for sure it was Dr. Nadalo. I don't recall completely of Dr. Santos had that same issue just offhand. But all of that was produced to you all on the 10th of December.
Correct, Your Honor, yes.
Okay. No, I don't really have any questions.
With the exception of, Your Honor, what wasn't produced is the Legent Hospital MRIs or the X-rays that were referenced in the medical bills or in the medical records, the newly produced medical
So
records.
those were not produced on December 10th in this batch.
We still don't have them, as a matter of fact. They still haven't been produced.
Okay. Okay.
Let me know when you're ready to respond from Your Honor.
Well, Mr. Peña, Ms. Garcia, do you have anything else? I think I understand. Okay.
Nothing further, Your Honor.
Nothing further, Judge.
Thank you. Ms. Lapinati?
Yeah, Your Honor, may it please the court. So as the court remembers, and my right before trial, one of the bases that I asked for continuance, aside from the issue with having my co-counsel recused, was that we had discovered that we were missing medical records. And I had said there's even a wrong MRI that referred to a shoulder when it should have been a back with Prestige, and we discovered that we're missing records as we were doing trial prep with our clients. So we were trying really hard to get that in a very short time notice. And that was, I mean, I put that in the record, should be in the transcript. Mr. Peña told the court, no, don't give her the continuance, we're ready. And anyway, the case was continued. I advised, and I had no idea what I was going to see. I said, you know what, I'm about to get records. I have been calling everybody, sending emails at night, we're missing records. I realized when I was getting ready. And so long story short, I advised them and I did produce what I got. My understanding is that Legent is no longer in business, which is one of the problems and the reason they closed, they went bankrupt. And so I have had no ability to get anything else other than the other records, which my understanding was because there was a lot of it telemedicine. There was COVID during this time. This accident happened during COVID, where there's no police report. So there was some records that were in through a portal that were not transferred. And so I was working very hard and diligently to start to get this information that I realized I didn't have. I realized that I couldn't find anybody from Legent. So I got as much as I could. The moment we got them, my office stayed late at night. We put them together because we didn't know if we were going to actually go to trial. So we got them ready and we immediately, we sent as much as we sent to the other side. So that was before the Daubert hearing. They had a notice of a Daubert hearing after I got the records. In fact, my expert testified he had not seen this records himself. He was cross-examined by Mr. Peña on the same subject, and he said, you know what? When I wrote the opinion, I didn't have these records. I didn't review these records. So we went through with my expert, my own expert, at the date of the hearing, page by page by page. And they're experts. They're hired to give opinions. At no time did my expert or their experts tell this court in a 6-7 hour hearing, we need more time to review that. I read the record. They understood the records. They gave opinions on those records. And their opinions were not modified or changed. They still stuck. Well, the court heard the opinions. So it wasn't like, oh, got you. And they were like, oh, I need time to review. I read it in the record. We discussed it together, the findings. What's more interesting, Your Honor, the MRI, it's the same. So the findings of the MRI on the 6th, the Legion MRI, are almost identical, but I think for the pars fracture, because fracture doesn't cover it on the second MRI because time has passed. Everything else is identical to the Prestige MRI, who they relied for their opinions. And also what's more interesting, Your Honor, is that my motion to strike was submitted to this court before I even had these records myself. The basis of my motion to strike, even without new records, still stands. Like, I did not change my motion. I did not even add the new records. I included in the hearing. But if the court remembers very well with Dr. Nadalo, I even said, let's forget about the new records. Let's forget about the old MRI. Let's focus on Prestige MRI. And with Nadalo, I specifically, because they were objecting, so I specifically used the Prestige MRI for all the cross-examination. And when he says, I haven't seen the Legion, I don't want to talk about it, even though we agreed they were the same, I said, okay, let's focus on what you relied, you relied your opinion or your basis of the opinion. So my motion wasn't on some got you new records. It was based on the old records. And my motion is on the record, is on the system on 1110. And the unreliable opinions on the old records. It's not even on the new records. I mean, that adds on more, but I specifically, especially with Nadal, I was like, you know what? Let's just focus on the MRI. So they're trying to really confuse you. What are the issues or our basis or our motion to strike? Let's not get confused. Let's look at what the facts and the data are. We relied on an unreliable methodology and opinion on an MRI, and let's focus on the Prestige MRI. And that was exactly my cross-examination with Nadala. He says that MRI cannot, he says one thing. The basis of his opinion is only the Prestige MRI. He says, I am focusing on MRI because he's not an orthopedic doctor. He cannot give any other basis. So I said, okay, let's focus on the Prestige MRI. He says MRI cannot show timing. The court remembers that. Cannot rule out trauma. He said, just because my client is old, that's why his opinion that this accident did not cause the trauma that is documented on the medical records that he allegedly gave his opinion on, which is the Prestige MRI, which they've always had and they've based on. He testified the MRI cannot show pain. He testified the MRI cannot show dynamic instability. He testified that the MRI alone cannot show causation as an accepted medical methodology. I said, the doctors rely on the symptoms. The doctors relies on clinical findings. The doctors relies on the complaints of the plaintiff. You agree with me, plaintiff went to the ER. She complained of back pain, numbness, neck pain, shoulder pain. All of these are consistent with symptoms that are as a result of a trauma to the body after an accident. And he agreed with that. He agreed with everything. And he even disputed Santos' opinion that says you got to have a fracture for a disc herniation. So the expert didn't even agree with each other on what the opinions are. So he says, no, that's not true. You can have a disc herniation without having a fracture in the back. Going against Santos' opinion. He testified that degeneration can coexist with trauma. He testified that trauma, he agreed with me that trauma can aggravate or accelerate degenerative condition. He says that he cannot rule out aggravation.
Your Honor, I've got to object. What are we talking about here?
I didn't interrupt you, so if you can allow me. So my point, Your Honor.
No, hold on, Mr. Pena. Okay, so let me tell you what the crux of my concern is for today. It is not so much, I understand the substantive issues from the opinions, the testimony that we had at the Daubert hearing, 2 weeks ago, however long it's been, 10 days ago. My concern is this. So, Mr. Peña, you stated that, okay, so what's clear to me is that there are several records that plaintiff's counsel did represent in the motion for continuance were newly discovered or pending. I can look at the motion here and see. I think it was the first reason. It was less so, even though I know at the hearing on the motion for continuance, we were really talking about having attorneys available. But the motion for continuance that was filed by plaintiff says, since the current trial setting, critical new medical records have been produced. Okay. And I understand that the timing of that is probably, what we would have all preferred. And certainly the discovery control plan had a deadline much sooner. But there were documents and there were records produced on the 10th of December, 2025. I can't assume anything with regard to opinions on whether there were differences, things of that nature. Certainly, I didn't hear a response, or nothing was filed by defendants about these new records. I just kind of feel like they're left hanging out there in December. But my question is this, Mr. Peña, you're saying that with this December 2025 disclosure of Ms. Garcia, that there are still medical exams, I'm not sure if I'm clear if it's x-rays or MRIs, that have not been produced.
That's correct, Your Honor. The Legent MRIs that, frankly, Ms. Labinati strongly cross-examined both of our experts on, and the fact that their opinions were not based on those MRIs that she at least intimated existed.
Hold on a second. So this is what I want to know. I want to know, where are the Legion MRIs? Have those been disclosed to Mr. Peña?
I don't have them, Your Honor. Legion is closed. I have no way of finding out I only have those reports, which is why I then used Prestige for purposes of Nadalo and the MRIs, because I don't have the images or anything. I mean, I have given everything I have been able to retrieve, locate in this unfortunately very old case that some treatments happened during some unfortunate times in our country, COVID. So and then now the facilities have closed. I can't locate anything. I have given everything that I have been able to fix and locate, even with Prestige that we had the wrong image. It was on storage. They couldn't locate it. So I only was able to print like the page, but I still wasn't able to get the actual images even for Prestige. But I have given them everything. They gave opinions on the MRI of Prestige, and they had no problems with that. And my motion to strike was absolutely based on the records they had even before December 10th. And I believe they failed in that respect. They failed on the Prestige MRI. Their opinion were unreliable on the basis of the Prestige MRI, the medical treatment, the urgent care. They literally gave conclusory opinions with regard to those medical records. And with regard to biomechanics, I mean, his argument of there is a fracture of vertebra, and that's the only way you can have a disc herniation. There is no fracture anywhere on even in the initial MRI, but irrespective of that, I focused on Prestige. I started with that and the chronology, but then I changed it to the Prestige because I was like, okay, you're saying you haven't seen this, but let's talk about the records that you have seen. And if the court remembers very well, the biomechanic relied on an opinion that only he has published apparently, and is no else to be heard.
Okay, hold on, Ms. Labinati. So I want to ask, I understand what we heard at the Daubert hearing. Okay, my concern, and where I'm going to go back to Mr. Peña, is what are you so you've heard the representation by plaintiff on the Legent MRIs, right?
Yes, I did.
So we have the only let me understand, let me hear from you, Ms. Labinati. What do we have from Legion? We just have billing notations that these MRIs were conducted. What else do?
I don't have anything from Legion. The only way I found out about Legion was from the portal of Dr. Johnson referring to it. So the reason they were not, I didn't even know myself. I mean, my client says I had an MRI before but I didn't know. And I mean, she doesn't remember. It's an old case. I'm trying to, so then when I saw that, then I said, oh, it's Legion. When I try to get a hold of Legion, they don't even have, there is no Legion. Like they don't exist anymore. And so I haven't been able to even find anyone that this could even exist. So I have given everything I have, and we got the telemedicine extra that we're missing because they were out of the Dr. Johnson's old portal during the COVID, because I think they used another company. And so I was able to get that, but that's all I have. Like, I don't have anything else. And I even tried to get the Prestige because I knew that that was also wrong. They gave me a shoulder versus a back, and I wasn't even able to get that because apparently, because of the age of the case or their storage, I don't have it. So I have
And
given
Wanda,
them
Hold on a
everything.
second, Ms. Garcia, hold on.
yeah, may I respond? So Legion Hospital apparently was sold to UMC in 2023. We actually contacted UMC to obtain these records, and they directed us to Legion Hospital in Houston, who they said would probably have the records. They gave us a person's medical custodian number to call. This was as of this week that Legion is still in Houston. They didn't close or get sold till 2023. And so right now we're trying to obtain those records. So I know plaintiff's counsel is saying,
Hold on. So, okay, thank you, Ms. Garcia. That's my question. What are you asking for, Mr. Peña?
Your Honor, at a minimum, here's the problem that we've got. I can't rely on Ms. Labinotti's statement that Legion doesn't have records. If
I didn't
they
even know you contacted Legion. I don't know Legion.
Your Honor, if I may address the court.
One at a time, please. Thank you.
Your Honor, so what we need to do is make a determination as to what records exist. And, frankly, keep the Daubert determination from the court open and carry it along with the trial. Hopefully we'll have the records and the experts can testify based on these new records that we're just getting on the eve of trial. Aside from that, Your Honor, certainly if we don't have those records going into trial, counsel for the plaintiff should not be able to argue and cross-examine these experts based on records that were never produced and that she doesn't even know exist at this time. So at a minimum, we ask that the court keep the Daubert hearing open, carry it along with the trial, give these experts an opportunity to see the MRIs if they exist and supplement the reports in advance of their testimony. That's all we're asking.
Your Honor, my problem is that I think the experts gave unreliable opinion, and my motion was even focused on the old MRI without even needing the other MRI. There is nothing in the MRIs that would change their opinion because
I can't assume that if we don't have the records. That is my problem. You might be 100% right, but without the record, I can't assume. I mean, there were several times, and maybe I'm misplacing my recollection, because there were times when we were referencing things, and particularly with Dr. Nadalo, he was stating that, well, if I had the opportunity to review that, might change, might not change. And that's the problem. I can't assume that something when we don't have it. So I don't even know how. I'm very concerned about even keeping the trial date. I don't have a problem leaving the Daubert hearing open, because at the very least, we will have some records and they can supplement. And if there are new concerns if there are changes in opinions, methodology, we have covered up until this point, and they can amend or supplement any other opinions for all of the experts. But the timetable is very tricky because we're set to start. We would probably be having this hearing on the 4th of February.
The issue you have, Your Honor, is that when I got these records to them on December 10th, how come none of their experts looked at the records and say, hey, I am missing
I
this
agree with you
information.
there. On December 10th, I would have expected this issue to come up on December 10th before we had a Dauber hearing. And
Or
at that point,
before.
but it doesn't cover then still the missing records, which may make a difference, may not, but there's certainly a set of studies that are missing right now.
Well, and my only issue, Your Honor, is that here we wasted hours of hearings, hours of time and preparation on my end, and at no time did they say, hey, my experts need additional time because we were missing additional records, and we just got this record December 10, and we need this additional information. So literally, like, they knew of the hearing, they were so excited to come at the hearing. I mean, we paid experts, and I am not a billion-dollar insurance company like they are, but unfortunately, we had to pay experts money to show up and testify. I mean, I wasted a day of preparation, a day of hearing time, and at no time did this came up. So at the end of the Daubert hearing, at the end of it, it wasn't even in the middle. It wasn't even, at the end of the Daubert hearings at 5 o'clock, 5:15, after the hearing doesn't go too well for them, that's like, oh, well, we're missing the records, even though I saw it coming. So what I did during the hearing, is that's why I'm frustrated. I specifically said, okay, well, let's forget about that. Let's just focus on the ones that you based your opinion and relied. That way, because I wanted to, I saw where Mr. Pena was going to go next after our like around 2 or 3 o'clock. So specifically, I started to focus on the records that we had, and I was trying really hard to show the court how unreliable their opinions were on the methodology, on data and ipsy-dixit conclusory argument, based on my initial motion, which was based on the old records. And so that's where I have my frustration on the energy, the time, the effort, the money that was spent on putting all of that together. And at no time did they say, wait, we need this information. But here now at 4 o'clock, after their experts clearly showed in the records that their opinions were unreliable, now it's like, oh, well, let's see if we can come up with an argument so we can run away from the problem, when they all testified that based on their records that they had reviewed, clearly their opinions were unreliable. And so I guess my point is that new MRI, or if there is a new MRI, in the reading, at least as shown in the medical records, is the same. Like if it was a different MRI, meaning it had a different findings, I could see the argument. It's like, well, it had a different findings. Had I known, but it's identical. So if you look at the shoulder MRI on Prestige and the findings on the Dr. Johnson that it's reading from Johnson, is the same. If you look at the neck, it's the same. So I'm like, okay, like what is it that in that MRI you think, if it was there, would change your opinions? And so I just feel like this is just another tag. I mean, if we can, like, I think the court can rule just on the old records. And if that's the case, they will need more time. Then this is what I would ask, Your Honor, that the court request from the experts to put in a medical report, not attorney's argument, that they feel that this information would be necessary for them to give the opinion. And I would, if the court can ask that order, and I don't think that's much to ask after we spend all that money to put time and effort, I would like for the court to request from the defendant's expert to put in a report affidavit to the court exactly what is it that they believe that MRI, as dictated by Dr. Johnson that day, would need it in an image that they believe would change their opinions, or it's necessary for them to supplement their opinion.
Savanati,
I think that's fair.
How can we have an expert sign an affidavit about an exam or a medical record that nobody's seen?
Well, it's documented in Dr. Johnson. So he documents what he reads in there. So that's what
Oh, man. So Miss Levinati just froze. Mr. McElroy, if you're nearby, you can let her know.
That's what I'm trying to say. Like, I mean,
Miss Levinati, you're freezing, and it's probably not necessarily your fault. But I think I
don't know,
understand your
Your Honor.
request.
I just don't think, Your Honor, that their opinions were at any time during the hearing, they said, well, had I had this information about this part of the report, I would have changed my opinion. They still stuck to their opinion despite me reading what's documented in the record about Legend. So that's my only thing.
I understand. What would be a realistic timetable if you all are going to pursue requesting these records? I mean, I can't imagine it's anywhere that gets us close to our trial date.
Your Honor, I think that if they exist, we should be able to know that within the week, if they exist.
All right.
And again, Your Honor, I really don't want to go back and forth with Ms. Labinati, but I recall very clearly, not only did the court have concerns, we had concerns. Dr. Nadalo on 3 or 4 different occasions kept saying, I expected the Rincon Law Group to produce the radiology, the films, those sorts of things. It was absolutely critical to him. And again, I think the court's right on point. We don't know what we don't know. We can't testify about things that we don't have in front of us. That's why it has to be produced, and the experts have to analyze them. And that's what all we're asking.
Well, the records I read to both experts, Your Honor, were records that were produced to the Rincon's law firm on December 10, and that Rincon law firm had failed to produce to either of their experts as of January of 2026 at the time of the hearing. So for 1 month, Rincon law firm, their attorney had records in their possession that had not produced to either of their experts at the time of the hearing. So what I read to them was not something that they did not have the ability to have. It was not given to them by the Rincon law firm.
The only thing that is really missing, even though I understand there is a group of records that were, I'll say late, right? Because they were December 10th. The only thing that is missing is these additional Legion MRIs and maybe any, related records. So let me ask this. Of the documents that were produced on December 10th, have those been provided to your 2 experts?
They have.
They have. Okay.
They have now.
And have you requested a supplemental report based on that?
No, Your Honor, they need to see the MRIs. That's exactly why they were hired, as they are radiologists and neuroradiologists. They need to see the films themselves. And again, I have a great deal of respect for Ms. Labinati and for Dr. Johnson, but that's Dr. Johnson's interpretation of documents. We need to look at the source documents themselves. That's what the radiologists do. That's what their expertise is in.
Well, look, you all, meaning you, Mr. Peña, seem very optimistic in that those documents, fingers crossed, you all may be able to get those Legion records within a week. So,
I'm hoping.
Counsel, I'm going to allow that. All right. And I'm not going to require an affidavit. I am just going to allow counsel to get those records. What seems to be like the last batch, right? We haven't identified at this point anything else that's outstanding. And I need to have that update within a week. And as I mentioned, I don't know if it was off the record or on the record, we are going to be in trial. So that's going to mean an email circulated to the court indicating whether we have them or not. Because frankly, if we don't have them by Wednesday, which I think it's still tight, but you all can give your experts heads up if they are already produced at that point, if they're going to do a redo or supplement their reports. And then I will continue a hearing if I have additional amended or supplemental or amended reports and opinions from your experts. at that point, it's going to be tricky with the scheduling, but then we'll proceed on that. But I do take not issue, but I don't think our hearing was a waste of time. We went through a lot of issues, and I have a handle on those. I just want to close the circle on this to make sure that we've encapsulated and included everything, to include the December 10th disclosures and now these last bit of medical records. And if from that point, let's say nice scenario, we get our records Wednesday, right, a week from today, and your experts are all really diligent and they review it, and golly, in 24 hours, they've decided they either do or do not have a report. Let's say they don't, then let me know that. We will set a follow-up hearing. Let me get to the calendar because we will be very, very tight on time. So we're talking deadline of the 28th. I think we have to do this February 2nd. And I'll say in the afternoon, if you all will look at your schedules. The reason I say in the afternoon generally is because we might still be in trial if we're at punishment. And so we're just queuing everybody in. So if anybody has a problem with the afternoon on February 2nd.
That's fine, Your Honor.
Ms. Labinati, your scheduling, can you guys accommodate just about anything? That's
we're going to have other attorneys cover other things.
So I'm gonna say 2 o'clock.
Okay.
On February 2nd, 2 p.m. And
2 p.m.
I will say this, you all will update us by the 28th with records and the prospect of having new reports, because this is what I'll say. If we have nothing, then we're going to come to a final on the Daubert hearings. Okay? If there's nothing else, we reviewed, blah, 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 all those things. If we have supplemental opinions, amended opinions, we're going to have a full-blown hearing. So bring your snacks and your coffee or your Starbucks, whatever. And we're going to get into it, right? We're going to follow up with anything substantive like we did at the last hearing. Okay.
That's fine, Your Honor. Thank you.
And that's only, Your Honor, for all the experts, or just
all
because
of us? Because I was saying defense, but frankly, maybe your expert has something too. So it's free, not a free for all. It's for all. It's equal for all. So I just please remind you, we will be in trial, and so bear with us in terms of emergencies and responses and things like that, because we'll be in a very busy schedule, unless we don't get a jury, and maybe I'll let you know. We've got 2 panels. They asked for a third one, 260 people. If we can't get a jury out of that, yikes. But we're working. So I really do appreciate, and even the long day that we had on the experts, I get it. Let's just wrap this up, and God willing, we can keep our trial date. I'll tell you right now, when we started, I was very skeptical. Very skeptical.
This is my oldest case. It's like a curse.
No, don't say that. Don't say it's a curse. We'll get through it. I'll just be really ready for the CLE.
It's like it's funny because I objected to Carlos. Carlos doesn't still talk to me because of that objection and continuance, and here I am. This case keeps on getting
pushed on giving.
That's my curse.
So okay, folks, please feel free to let us know of any unexpected developments. Just make sure everybody's on that email chain. I don't always like to do that, but I know when we're in trial, it's sometimes the most efficient way to do things. So
my motion to exclude, Your Honor, is going to be moved to the docket call. I was just, or do we want to do it here this day?
I'd say be ready. No, I would say be ready for that date on the February 2nd.
Okay.
And
I
if we
think
can't
yes.
knock it out, then it'll be on the 4th.
You're-
I don't think it's going to be very long, Your Honor.
Okay.
Not like the Daubert hearing. I
Okay.
probably think it's 30 minutes, maybe 40 minutes top, but I
Okay.
think it's pretty short.
Okay,
Your
don't
Honor,
jinx us. Okay, yes, Mr. Peña.
Your Honor, just to make sure that we're communicating, Your Honor, at a minimum, I will submit via email a status report to the court as to what the status is with regards to obtaining those records by next Wednesday, at a minimum.
Okay.
Thank you.
Thank you, Your Honor.
Yeah, I guess the question is going to be what happens if we don't get records?
Exactly. So again, I'm hopeful. So at a minimum, I will submit a report to the court.
I Miss Laminati. Think
I'm telling
positive.
you, Judge, I should have been nicer to
positive.
Carlos. I should have said yes to like the continuance when he asked. Maybe I would have gotten some better karma.
All right.
I'm kidding, Judge.
Let's see. Let's see how we do. Yeah.
Yeah.
We'll live to fight another day. All right.
Thank you, Your
Anything
Honor.
else?
How is the Zoom, Judge? The audio, the sound? I
So
know
I
the
don't
court
know
was
if you
working.
noticed on that date, they were tweaking the whatever it is, the box that we have here in the back, and it was better. I will let you know as we go through this trial, how good it is.
And I don't remember, Your Honor, for purposes of trial, did the court order the expert live or via Zoom? I'm sorry, I just don't remember.
I didn't.
Oh, you
I
did.
didn't order it. I just commented that from the last civil trial, the jurors were very consistently not loving video testimony, and that did not have to do with audio. Okay, that I think we still had the speakers at that trial, and it was clear they don't like them. So, if
Right.
I see, the only thing that would change that is that as we get into our criminal trial tomorrow, if I see we're having some real issues, we will put you on notice right away.
Okay, Judge.
For
But
input.
I think most of my doctors would be live. I don't know if one of my expert will be able to, but and I think they're already upset because they already texted me, when are you gonna call me? And I'm like, oh my God, what do I tell them after today's hearing? So yeah.
And don't forget the scheduling for February 13th, right?
Right.
Yeah,
Right.
that's another thing. And I don't think I've mentioned to you all, well, let me ask, is there anything else on this case?
No, Your Honor.
All right.
Thank you.
Thank you very much. Let's get off. Good morning, everyone. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for January 28, 2026. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we're streaming all matters live via YouTube for public viewing. Mr. Nunez, would you call our first case, please?
Yes, ma'am. Page 1, calling cause number 2023 DCV 3936, Crystal Garcia versus Juan Jose Galvan. Announcements, please.
Good morning, Your Honor. Ashley Cedillo on behalf of the plaintiff.
And I do see Mr. Flores, you're there as well.
Good morning, Your Honor. Renee Flores for defendant.
Good morning. Entry of judgment. How are we doing on this one?
Your Honor, because of the fact that we had a pending UMUIM and that information needs to be taken into account in order for any health insurance liens that play a role for the settlement, opposing counsel and I have already discussed that instead we're just going to do our normal procedure of obtaining a settlement check, keep it in our trust account, so that way we can submit proper dismissal documents to the court. They already have executed release. The problem is that we can't get proper drafting instructions from the health insurance without our UMUIM to carrier settle as well.
How long do you think that will take?
To settle the UMUIM case, unfortunately, it may take a little bit longer. So that's why we're just going to hold the funds in trust. We're going to put drafting instructions and inform them. It already has hold harmless language in there. So then that way takes care of defendant's concern. And then we'll move forward and we can hopefully get dismissal documents to you signed within 30 days.
Okay, so I'll put this about 45 days out. We'll just reset it.
Yes.
Thank you so much. If you all don't have anything else, you are excused. Have a good day.
Thank you, too, Judge.
Who's next?
Judge, page 1 also, calling cause number 2025 DCV 1090 Liliana Nunez versus Morval Construction. Announcements, please.
Brock Benjamin on behalf of Mrs. Nunez, plaintiff.
Corey Hoagland for Andres Morial, DBA Morval Construction.
Okay, I have this down for, there is, I guess, no agreement on the extending expert designation. Mr. Benjamin, what is it that you're requesting? Is it your request?
Your Honor, I'll let Mr. Hoagland go, but I think we've resolved that, and I was going to submit an order with a 2-week extension for him and proceed. Do you mind going, Mr. Hoagland?
Yeah, we've agreed that he can go ahead and do his late designation of testifying expert, but I want a 2-week extension from the date of entry of his order that allows us to designate testifying experts. So with that agreement, I don't know, as I told him, if he already has an order over before you, Judge, on his motion, you can sign the order that he submitted. And it's just our Rule 11 agreement is the defendant, the counter plaintiff, gets a 2-week extension for designating testifying experts from the date of entry of this order.
Okay.
And that's correct, Your Honor.
And I'll just ask Mr. Benjamin, do I have that? Do I have an order from you?
Your Honor, I'm going to go ask Denise real quick, but I will get one to the court before I leave the office on my way to federal court right now.
Sure. Okay. I'm just asking because I haven't gone through all my emails this morning, and sometimes we get those right before we start our docket. So
it didn't get sent today. If it didn't get sent with the order when it was the motion when it was filed, Your Honor, I'll have to submit one today.
okay, if someone would do that, please, and I'll go ahead and sign off on it. We have future settings, correct? Yes, we do.
We do, Your Honor.
All right. Thank you very much. If you don't have anything else, you're all are excused.
Thank you, Your Honor.
Thank you, ma'am.
Have a good day. Bye-bye. Who's next?
Judge, page 1, calling cause number 2025 DCV 1117, Laura Gabriela Embry Melton versus Robert Aguayo et al. Announcements, please.
Manny Morgan for plaintiff, Your Honor.
And, Mr. Flores was here. I had show him.
I am still here, Your Honor.
Okay. I'm all right, Mr. Flores. Are we expecting anyone else?
I know Geico's on the case, Your Honor, but I don't anticipate they're gonna make it.
Okay. So this is a scheduling status conference. How are we doing? Do you need a trial date?
No, Your Honor, we settled the matter entirely, and so the only issue is we do have a pending lien. So I would ask maybe for 45 days, Your Honor, to try to get that.
So I was going to give you 60. I'll just stick with 60.
Okay, I appreciate
All
that.
right.
I never know. It's like, but yeah,
That's okay.
it's going to be difficult, but hopefully within 60 days we should get it.
Sounds good. Anything else?
Not from plaintiff, Your Honor.
All right.
Nothing from defense, Your Honor.
Thank you very much. Again, if you don't have anything else, you're excused.
Thank you,
Thank you, Your Honor. Have a good day.
You too. Mr. Nunez, who's next?
Judge, page 1, calling cause number 2024 DCV 5197, Sandia Laboratory Federal Credit Union versus Tristan Lee Carpenter. Announcements, please.
Good morning, Your Honor. Sebastian Uribe for Sandia Laboratory Federal Credit Union.
All right. Mr. Uribe, this is a status conference. Let me see what's going on here.
So, Your Honor, we will actually be filing the default judgment. It's taken this long because he was in the military, but he's not active anymore. So we will be filing that soon.
Okay. So I will reset a status in about 30 days. If you get your default file with plenty of time to send notice, all those kinds of things, you can anticipate using that setting with your request for default. So you send in your default, ask for a hearing, we can use that date. If it takes more time and we're way too close to that date, then we'll actually schedule another date, okay?
Okay, that works, Your Honor. Thank you.
Okay, thank you very much. Bye-bye.
May I be excused?
You may. Have a good day.
You too.
Next, Mr. Nunez.
Judge, bottom of the page, page 1, calling cause number 2025 DCV 4943, Chuco Ray Holdings LLC versus City of El Paso. Announcements, please.
Good morning, Your Honor. Patterson W. Kime on behalf of the plaintiff, Chuco REI Holdings, LLC.
Good morning. And anyone here for the city?
No, Your Honor, here, I can kind of walk you through the status here.
Sure.
This was originally a petition in connection with an application for a temporary restraining order, which was obtained. We actually were able to resolve this even before we got citation out to the defendants. And
Mhm.
so we're going to be filing a non-suit pretty soon here. And also there was a bond posted in connection with the TRO. So we're going to be filing a motion to release the bond at the same time as the non-suit.
Okay, can we get that done pretty quickly?
Yes, Your Honor, it's
Yes.
drafted and ready to go. I just, the attorney of record here, Mr. Fuel, it's on his desk right now, just waiting for the green light.
Okay. Okay, Mr. Fuel, I see you're there.
Putting anything on my desk is dangerous, Your Honor. So I will look at it. Post haste.
I'm gonna reset my status for 2 weeks, just anticipating we'll get that. If not, I'll follow up with you all, okay?
Thank you, Your Honor.
Thanks, have a good day. If you don't have anything else, you all are excused.
Thank you, Your Honor.
Have a good day, bye-bye. Mr. Nunez, who's next?
Page 2, Judge, calling cause number 2024 DCV 4577 M&T Bank versus Olademi G. I'm sorry, Judge, let me bring in this.
Oh, yeah.
Miss Olademi, I don't see her anymore. She was in the waiting room, Judge.
Yeah, she kept checking in if I'm
sorry, Judge. Let me start it over again. Calling cause number 2024 DCV 4577 M&T Bank versus Olademi G. Bamidela Pamuwaiwa.
Good job, better than I can do.
Announcements, please.
Good morning, Will Morphus on behalf of Plaintiff M&T Bank.
Again, ad Hunchu, court-appointed guardian ad litem. Well, actually just ad litem, Judge. I represent the defendants. And I have here also, Gabriel, can you unmute?
Yeah, my name's, are you saying Gabriel or Gerald? Sorry, I'm Gerald Gonzalez.
I'm sorry, Gerald, where are you?
I am, oh, sorry, my camera turned off.
Oh, there you are, sorry.
Yeah, Gerald Gonzalez. I'm a realtor for Mr. Fondamwe, trying to assist in the sale of his home. We're in a short sale process at this time.
okay. So, Mr. Morphus, I think
Yes,
last
Judge.
time we were here,
Yeah.
we were having difficulty getting in touch with Miss the wife, right?
Yeah, that's correct. And we had determined that she had actually appeared in court at a previous status conference, so therefore she had waived, the service requirement. My plan was after that hearing was to immediately prepare a MSJ to file to get it disposed. Not less than 2 hours after that hearing, M&T put this on a hard loss mitigation hold because of the short sale process. So they instructed me to not file the summary judgment based on the hold so they could go through the loss mitigation. So that's why the summary judgment was not filed. Ms. Hanshu requested a payoff on Friday. We requested it on Friday. And I'll send the payoff figures as soon as we have it. And we did send one that was good through January 16th, but just with the way the review's been going, we just needed a little bit more time to get the closing and the short sale process completed. So as soon as we have that payoff, we'll send it over. And based on what I can see in my system, the loss mitigation hold is set to end on March 9th.
Okay. Is that the timetable then we need to use the post March 9th? Maybe I'll set this for another status and see where you all are. Or are you all asking for something other than that?
Well, Judge, let me ask Gerald. And Gerald, sorry, I was looking at Gabriel, and so I said Gabriel.
No worries.
I
No
apologize.
worries.
Gerald, can you tell us where you're at in terms of selling the home and
Definitely. Well, M&T did reach back with a counter, which we did now present both to the buyers, and the sellers are actually in the process of e-signing those right now to get them back, to get the information they had requested adjusted. I think I had shared just now kind of a screenshot of what they had suggested, what changes on the counter per se. And as of right now, the buyers are excited about trying to obtain this property to live in it. To my understanding, and they're just waiting to take the next steps to get closed. I don't know if the 9th will work. I know originally M&T Bank or loss mitigation had told me to put 2 months out for closing. So I guess they just want to have plenty of time to navigate the process since VA is also involved.
That is going to take longer. Based on just the last letter that Will sent us, Will and Gerald, does it look like the house will sell for the payoff amount, and will that suffice? And then if so, what are the next steps so the court knows what else you need from us?
In essence, it's going to keep kind of on the bank side. So both the sellers and the buyers have signed. The contract itself has not been executed. I guess the loss mitigation has to execute it once they agree to the terms. So we could just go through the normal process of acquiring the property. They did tell me it was a slow process. I've been reaching out to them several times to discuss, anything that might be needed or if docs have been reviewed, but the process has been going slow. They have told me to give them plenty of time to review the docs. Even though we get to them sometimes right away, it's like a week or so before they get back to me as far as what the next steps are. But as of right now, it all looks fine. Everything seems to be moving forward. They do emphasize every time that it's a slow process every time I talk to loss mitigation.
So thank you, Ms. Hanshu, for going over that. For my purposes then, I just think I would bring you back for a status April 22nd. I don't know if that, if anybody else has a different suggestion, but it would just be a status conference for me and to see where we are, get updates from you all. If something happens in the interim and you need a setting before then you can just advise the court and we can come back sooner unless you need something else from me.
Well, I just had a question, Your Honor, and this question was posed by Will as to how much longer you want me to stay on.
Yeah. Like I want to say we're good to go, Ms. Hanshu, and then I feel like I'm going to find out on April 22nd that your assistance would have been
okay.
But honestly, I'm good. Unless anyone has any other requests or suggesting that she stay on, Ms. Henshu, I'm going to go ahead and allow you to terminate your ad litem role in this case. Anyone have any concerns about that, Mr. Morphus?
No, Your Honor. We will pay her as soon as we get the signed order and the W-9.
Okay.
Thank you, Your Honor. Then I'll pull up a bill and I'll circulate it between Your Honor and Mr. Morphus.
Thank you very much. Thank you very much. April 22nd at 10 a.m. It'll just be a status. And just for purposes of the record, Mr. Famuyiwa did log in, and we did see you logging in and out, sir, but I think the majority of this hearing you were on. So, so we'll come back on the 22nd for status. Okay?
All right. Thank you all so much.
Thank you for your time, and thank you for your assistance, Ms. Henshu.
Of course. Thank you, Your Honor.
Take care.
Judge, page 2, calling cause number 2025 DCV 3040, Raul Mendoza et al. Versus BJ Calderon et al. Announcements, please.
Good morning, Your Honor. Gabriel Perez on behalf of plaintiff.
Good morning.
And I don't see Mr. Rago here. He's or his daughter, Judge. They're on the other side.
Yeah, I see that.
Oh, there you go.
Oh, there we go. Miss Almaguer?
Yes, hi. I'm the paralegal for Mr. Rago. Good morning.
Good morning. Is Mr. Rago or Miss Rago?
He's currently in another hearing. I'm so sorry. He's currently in another final and another hearing. He told me to step in.
Okay, well, I'll take the notification, not necessarily step in, but Mr. Perez, you're here for a scheduling status conference. Are you all going to need a trial date? I see we had a default hearing back in November. So
correct.
What are we trying to do here? Are we trying to get our trial set, or do we need a little more time?
No, Judge, we need a bench trial setting if for just that's it. I mean, it'll be pretty straightforward. I'm still waiting for discovery. It's, I'm trying to avoid filing a motion to compel. So, but we do have outstanding discovery from the defendant. And once we get that, but if you want to set us maybe a few months down the road, we should get the documents we need, and then we can set it for a bench trial.
Okay, so I'm going to do a kind of like a 6-month timetable. We'll do a bench trial in about 6 months. How much time do you need, do you think?
Oh, half a day is fine. Just 3 hours will be plenty.
Okay. We'll do the bench trial setting, but we will do about 30 days before that, kind of like a final judges conference. Okay.
Sounds good. Perfect.
That's it. Okay, 30 days before. Thank you very much. Ms. Almaguer, you can let Mr. Rago, I mean, he's welcome to log on if he wants to, but we'll have our scheduling. And yeah, if he needs to come back, he can come on.
Thank you so much, Sharon. Have a good one.
Thank you, Judge. Take care.
Take care. Who's next?
Judge, page 2, Calling cause number 2025 DCV 1655 LVNV Funding LLC versus Robin Guadarrama. Announcements, please.
Victoria Barboza for LVNV funding.
All right, so let's see. This is a status dismissal. Oh, non-suit. We had a non-suit back on the 26th of December. Maybe we
Yes,
have an
Your
order.
Honor.
Did you send an order?
I can check with my office. If not, I will send one right after this hearing, Your Honor.
Okay, please do that. I gotta think that's the only thing that was outstanding, just looking at it right now. So, yeah, send the order. Thank you very much.
Okay, I'll get that in. Maybe excuse, Your Honor.
Yes, ma'am. Have a good day.
Thank you, you too.
Who's next?
Judge, bottom of page 2, calling cause number DCV 1276 Ruby Ray Puga versus Jaime Alberto Guerrero et al. Announcements, please.
Good morning, Your Honor. Jesse there for the plaintiff.
All right, so this is also set for status dismissal. It looks like citation unserved back in April, and then we haven't had any settings. So what's going on with this case, Mr. Herrera?
Judge, we still haven't, we've been trying to get him cited and the citation to be delivered. However, we're lacking a little bit of medical, and I think the defense, once they get the medical, I think we get this resolved.
Who's the defense?
The defense.
The defendant hasn't been served. The defendants haven't been served, right?
I'm dealing with Allstate, Judge. It's an adjuster with Allstate. And they told me, according to my staff, they said that as soon as we get the medical, they'll make an offer, and I think we'll get this thing resolved.
Well, I mean, this has been set for, I mean, there has been no movement. That's why it was set for dismissal hearing.
Okay.
So, I mean, what are you gonna file here? When do you anticipate settling? What has happened?
They made a really small offer, Judge, and then that's why we filed a lawsuit, and the citation hasn't been delivered. However, they say give us the additional medical, and we'll make a bigger offer and get this thing resolved. So if you give me 45 days,
We'll do 30 days, and I'm gonna reset it for status dismissal.
Okay, Judge. That
Thank
sounds.
you.
Thank you so
Okay.
much, ma'am. Thank you, ma'am. Excuse.
Okay, yes, sir. Who's
Bye-bye.
next?
Judge, on page 3, calling cause number 2025 DCV 1311 Jessica Salazar versus Sandra Montoya. Announcements, please.
Good morning, Your Honor. Connie Flores here on behalf of Jessica Mendez on behalf of the plaintiffs.
Good morning.
Good morning, Your Honor. William Moss on behalf of Clifford Jessup for defendant.
All right, and we are set for scheduling status. Are you all ready for a trial, or are you gonna tell me you settled it all already también?
I did text Mr. Jessup, but I don't know if he's out of town, but I said, pay me the money so we don't have to do a hearing, and I didn't hear from him. So I don't know. But I think we are ready
Are you copied on those, Mr. Morales, huh? All right, do we need a trial setting?
Yeah, I think we need a trial setting, Your Honor.
Is a year out good?
Yes, ma'am.
Yeah? Okay. A ver. Let me see if I have my 2027 list. Myrna, what trial setting are we looking at for these? Let's see. I would say February 12th, but I don't know how full we are.
It's available, Judge, for February 12th.
Okay, let's do that one. Is that one good with you all? You ready to spend Valentine's Day in trial?
If they pay me, we wouldn't be in trial, but yes, ma'am, that is we are available.
Mr. Morales, are you okay with that?
Let's just be clear, that's 2027, not February 12th. 2027.
Yes, 2027.
Just,
Crazy,
yeah, double
right?
checking. Yes,
I know, we're
that's
not
okay.
used to 2026 yet, but we're talking about 2027.
Your Honor, I am, just so you'll know, I am scheduled for another trial, but you know, in New Mexico, they have the 5-week trial dockets.
Oh.
So, I mean, I can't possibly not schedule for 5 weeks. So just as the court is aware,
I think just out of an abundance of caution, we should probably do March 19th instead, because knowing kind of some of the scheduling things that we had this year, kind of.
March is completely open.
Mr.
March is
Morales?
available for us too,
Sí,
Your Honor.
ándale, pues we'll do March 19, 2027.
Thank
You all
you,
know
Your
the drill, get me the scheduling order, all those things, okay? And agree to your mediator.
Yes, Your Honor. Thank you so much.
Have a good day, guys. Mr. Morales, you good?
Yes, Your Honor. Thank you very
Okay,
much.
take care. Bye-bye. Who's next?
Judge, we have Mr. Rago here. We already heard his case.
Mr. Rago, let me see, where are you? Mr. Rago, your office did chime in if you're there. Let me see. All right, let's go to the next case.
Yes, ma'am. Page 3, Judge, calling cause number 2025 DCV 1715, Linda Mendoza versus Antonio Salazar Jr. et al. Announcements, please.
Mr. Lucy, that's who it is.
Stephen Lucy on behalf of the plaintiff, ready to proceed.
Good morning, Judge. Joshua Murphy on behalf of Progressive.
All right, are we missing anyone else? Let me see.
Your Honor, I believe we are missing Jason Rose as defense counsel for my client Linda Mendoza and plaintiffs Kelman Dell. And from what I'm seeing, Your Honor, is that because I was confused as well, we have two different cause numbers.
All right, let me actually open it up here. And you have two different cause numbers.
Yes, Your Honor, we have this one, and then we also have 2025 DCV 1498 in Bonnie's court. So I think we have to file a motion to consolidate, Your Honor.
What's the other cause number?
It is 2025 DCV 1498.
Have you all discussed, have you all discussed that with the other attorneys? 2025 DCV, or tell me a little bit about it. I don't see a related cause number here, so I'm going to look it up.
Yes, because I understood that Cal Mandel was representing some of the parties as in the plaintiff capacity. And so before this hearing, I searched up the cause number, and I did not see Cal Mandel in there, nor the defense attorney for my client. So I got very confused. I started looking through the file, and we have two different cause numbers, Your Honor.
Okay, I see.
And it looks,
And Judge, we weren't aware of this second one.
Yeah, it looks like the older filing anyway is the one in the 171st. So is someone going to file?
Yes, you're correct, Honor. So I think we'll have to file a motion to consolidate and then transfer it to that court, to Bonnie's.
To Judge Ronhel's court. Okay, I'm going to reset your scheduling status conference for 2 weeks.
Okay, and I'll send over an email with all counsel, Your Honor, and say, hey guys, we need to handle this. We have two different cause numbers. We need it all together.
All right. So yeah, I don't know how quickly. Well, my timetable is 2 weeks, so we'll see you all in 2 weeks. Okay.
Yes, Your
Understood,
Honor.
Judge.
Thanks so much. Have a good day.
Thank you. Take care.
You too.
Take care. Bye-bye. Who's
Bye-bye.
next? Mr. Fuelwire, you're back?
Muted, sir.
You're muted, sir.
I'm muted.
Now you're
So yes, I'm back with Mr. Scherer.
Hi, Mr. Sheriff. I thought you all, what are you here on?
Well, there was the Bite Dreams case that I think has been dismissed, and we weren't sure whether we should show up or not.
Well, let me just say, I don't see it on my docket, and I appreciate you all showing up.
Well, it's nice to see
But
you.
I feel like I signed off on something that made me think that went away.
You did.
Yes. Well,
Yes.
It's dismissed.
okay. Well, thanks so much for appearing.
Well,
Thank you, Your Honor.
Have a good day.
Thank
You too. Thank you.
Take care. Bye-bye. Who's next, Mr. Nunez?
Judge, bottom of page 3, calling cause number 2025 DCV 0587, Wells Fargo Bank NA versus Gilda G. Morale. Announcements, please.
Good morning, Samantha Razzo appearing on behalf of plaintiff Wells Fargo NA.
Bear with me 1 second. All right. Okay, so no one here on behalf of Miss Moriel. No, we haven't seen anyone checking in, Mr. Nunez.
No, ma'am.
All right, Miss Razo, the motion was filed in December. Did you send a notice of this hearing?
Yes, Your Honor, we did send a notice of this hearing. Let me pull that up very quickly. It was sent on the 22nd. We sent it FedEx overnight, Your Honor.
Oh, wow. Okay. All right. Well, do you see anything with respect to the delivery? Was it just like dropped off at a home or something like that?
I'm thinking on here, let me pull that up very quickly. Apologies,
No worries.
all this weather change has got. Alrighty, so on here I'm seeing that it actually has not been delivered. It's due to deliver today. It looked like it was delayed because of the storm.
Mm-hmm. Yeah. Yeah. So for my purposes, I hate to do that again, but we're going to reset. Actually, I think that's probably the best way you could have relied on a notice being sent. So let's do about let's do 30 days. Let's just do 30 days because we might be in trial in 3 weeks. So we'll do 30 days. If you'll do the same thing, 30 days is what? Let's see, today's the 28th. We'll do February 25th at 10:30 a.m. You can send that notice, and you'll have your hearing, and we'll take care of it.
Perfect, thank you. And Your Honor, is it at the same Zoom link?
Everything's the same. Yes, ma'am.
Wonderful, thank you. May I be excused?
Yes, have a good day, and thank you.
You as well, thank you.
All right, who's next?
Defendants? Defendants?
And I have the motion to compel arbitration filed, and as I was mentioning briefly off the record, I see the plaintiffs filed a response. I was trying to go through it now. So just know that I may take a minute to go through in light of your arguments today, but Mr. Gagnon, you may proceed.
Sure, thank you, Your Honor. I've struggled, having received the response late yesterday, I've struggled with requesting an extension to January 28. And I like I say, I've struggled with this. I think that one of the points that is made in the response is that one of the defendants, Encino Metals, is not a party to the arbitration agreement. I disagree with that. The arbitration agreement applies to ESI, which is a professional employer organization, and its client companies. There is a client services agreement that I can provide by way of reply that establishes that Encino Metals is a client company of ESI to the extent that's an issue or a concern for the court. I don't have it. I haven't had a chance to request it. I had requested of counsel Mr. Mendez back on December 4 if he'd be willing to discuss why he was opposed to arbitration. Hadn't heard back from him. So that the response yesterday is my first look at why there was any opposition at all to this. So I think that so that the record's clear, I think it would be helpful to simply provide a reply that shows that they are a client company. The plain language of the agreement makes clear that the PEO, which is ESI, and its client companies are covered by this agreement.
Okay. All right, Mr. Ray, what's your position on? I'm thinking something like a 2-week extension of today's hearing. And I don't know if that's what you're asking. You kind of threw it out there without absolutely knowing if it's an ask or not. You said you were struggling with it, Mr. Gagnon.
Yeah, I'll go ahead and say I think it would be better to request the extension and provide a clean record.
Mr. Ray, what's your position on that?
Your Honor, I think irrespective of any document proving the client relationship with the PEO, I think the problem with the arbitration agreement itself is the vague language involved. I think the problem is the fact that Encino is never mentioned by name. It establishes that there's no privity of contract between Encino and my client. So ESI, the PEO, is using this arbitration agreement with indefinite amount of companies, essentially having each employee agree to arbitration, not just with EESI, but any, for lack of a better term, client that it works with. And the problem is there is no consideration with Encino with respect to this arbitration agreement.
Okay.
And so I think there's some contractual issues. So irrespective of the fact of any type of document proving the client relationship between the two, the vague language of the arbitration agreement doesn't change. They're
Mr.
not
Ray, in terms of the extension, do you have a position?
Not necessarily, Your Honor. I don't think, again, providing any additional documentation proving the client relationship changes the fact that this PEO is a co-employer with distinct rights under the Texas Labor Code, Chapter 91, that are separate from the responsibilities of Encino.
Okay.
And the fact that Encino isn't mentioned in this arbitration agreement, again, it's unconscionable in its substance, just due to the fact that there is no privity, there's no consideration given by Encino to bind my client to arbitration with Encino. Now, we're not disputing any arbitration with EESI. I think that language is clear given this arbitration agreement. But any additional documentation proving that client relationship, we're already running under the assumption, but that doesn't change the vague language of the arbitration agreement itself.
Okay. So I'm not sure if it's your request, Mr. Gagnon, but for my purposes, I am going to reset today's hearing, but kind of with a little bit of scheduling here. We are going to push this back, continue it to January 28th at 11 a.m. But I want some kind of interim deadlines to make sure that we are in a position to fully hear arguments. So Mr. Gagnon, if you could have any reply to their opposition filed by the 16th of January. And Mr. Ray, if you would like to then respond to that as well, please do so by the 23rd. And that's going to be the close of all the submissions for the arbitration issue. And we will hear it on the 28th.
That sounds good, Your Honor. We can send a notice to that effect, and we'll make sure to file on or before the 16th.
Okay. The scheduling status conference will also be reset for that date, so we can figure out what we're doing. Appreciate your time, gentlemen. With that schedule in mind, then if you don't have anything else, you are excused.
Thank you, Your Honor.
Thank you, Your Honor.
Have a good day.
You too.
And so now we have Mr. Azam and Mr. Silva for the last one, Mr. Nunez.
Yes, ma'am.
Calling cause number 2025 DCV 4315, Richard Medina versus AutoZone Texas LLC. May I have announcements, please?
Good morning, Your Honor. Omar Silva for the plaintiff. Ready?
Good morning, Your Honor. Koteba Azam on behalf of all the defendants.
Scheduling status conference. Are you all ready for a trial date?
We're going through discovery, so I guess from the conversation we had this morning, the trial dates are late December, early January. So I think that would be a good trial date, and we can work out the case between then and now.
You want December of this year? Is that what I'm hearing? Is it that?
Your Honor, it would be preferable if it's early next year. December of this year December's in my experience, in my limited experience, tends to be a very busy month. So it's preferable if it's early in the next year.
So I have January something, let me see. January 22nd. So that means your mediation deadline is before Christmas, okay?
Yes, Your Honor.
All right, January 22nd.
22nd. Let me just double check. Prosecution. I have to look at Kurt's calendar as well, Your Honor. The 22nd. It looks fairly open, Your Honor.
Mr. Silva?
Yes, Your Honor, that works for us.
Okay, so let's get our scheduling order done, returned, signed off on, don't have to come in for the entry hearing, and then any hearings outside of that, of those settings, please request with Ms. Hernandez and get your hearing. File pleadings. Reminders on summary judgments, you file them, we're going to hear them unless I have something in writing and filed that says you're withdrawing them, okay?
Yes, Your Honor.
Anything else?
No, Your Honor.
Have a good day. Y'all are excused.
Thank you, Your Honor.
Bye-bye.
Bye.
We all done, Mr. Nunez?
Yes, ma'am, that's everything.
Yay, thank you. Thanks, everybody.
I'm going to go ahead and call this one for the day, ladies and gentlemen. I appreciate everybody who watches. If you're not subscribers to this channel and you like this channel, just go ahead and subscribe to the channel and help the channel grow. All I care about is the growth. I'm not worried about being monetized or anything like that. But that's it for today, ladies and gentlemen. You all have a wonderful evening. Ta-ta and ciao-ciao. I will see you again tomorrow.
From the mountains high, high, come down to it all. With your tools in hand, hand, making magic flow. Every broken part, you help me grow. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's right when I'm falling apart. You put me back together. Daniel, you make it better. From the wires tangled up to the broken dreams. You know how to man all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright when I'm falling apart. You put me back together. Daniel, you make it better. Fix it, Daniel. Fix it, Daniel. Fix it, Daniel. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, fixing your album, standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's okay.